Hey, what is up, JMA fam? We're going to be talking about a case today, some tyrannical deputies over in Citrus County. Now, what they've done here is, if you're not aware where Citrus County is, it's this little armpit area over here in Crystal River and Homosassa. There's a lot of boating and stuff that goes on. But apparently, there's a man that has some pretty bad blood with some of the deputies there over some property issues. They ultimately charged him with 5 counts of wire communication interception, or the wiretapping statute. He's facing, or was facing, 25 years in prison for recording a deputy when he was filing a complaint. So we're going to take a look at some of the facts over here. Let's take a look at some of the facts over here. The case is pretty simple. I'll put it up here so you can see it. It's Michael L. Waite versus State of Florida. And there's the case number. And we'll jump down to the facts here. So what this does is it stems from a lengthy dispute with Waite and the Citrus County Sheriff's Office since 2018. Waite has been quarreled over property boundaries with city employees and the CCSO. But for this duration of this dispute, Waite would report what he believed to be crimes, so like trespassing and so on and so forth like that. But as his relationship with the CCSO continued to devolve, Waite started recording the conversations. In January of 2021, he called 911 to report what he perceived to be a trespassing incident, and that was involving one of the members of the CCSO. Waite insisted that he wanted to file a complaint with Internal Affairs and had an email ready to send. The 911 operator explained that she would have a supervisor call him back as she could not provide the information that he was requesting. Waite agreed and informed the 911 operator that he just wanted the phone call to be recorded. But later that same day, Sergeant Edward Blair called, and when he did, Waite decided he's going to turn the recorder on. In my opinion, legal and lawful, you have several cases: Smith v. Cumming, McDonough versus Fernandez-Rundle, Department of Agriculture v. Edwards. These all say you have to have some type of reasonable expectation of privacy. And as a police officer, you don't have that. As a public official, you don't have that. So he was on the phone with Sergeant Edward for 3 minutes and recorded this phone conversation. And when he did so and hung up the phone, he sent that recording to the records department and requested that an internal affairs investigation be done. But as you know, when you mess with the police, they're going to come at you with a strong arm of the law, maliciously prosecute you, make up stories. And here we go. In February 2021, Detective Jacob Chenoweth sought to obtain an arrest warrant based on the recorded conversations attached to Waite's email. Let me tell you, it says an arrest warrant. So it alleged that he violated 934.03(1)A, and that's the Florida's wiretapping statute. And he did so by recording the conversation with Sergeant Blair without his consent. After obtaining the warrant, deputies, including Captain Ryan Glaze, went to execute it at Waite's home. We talked about this is an arrest warrant. They didn't say search warrant. But as he's arrested, an altercation ensued, and it was alleged that Waite elbowed Captain Glaze in the face. But incident to an arrest, deputies found an audio recording device containing 3 additional recorded conversations with the CCSO deputies. Arrest warrant, search warrant. They seized this information here and then charged him with 5 total counts of wiretapping, battery on a law enforcement officer, and resisting arrest with violence. After his arrest and during court, Waite filed several motions to dismiss and suppress, including a Florida Rule of Criminal Procedure motion to dismiss the wiretapping charges. And Waite conceded that he did not inform the deputies he was recording and the conversation, and none of the deputies gave their consent to be recording. However, Waite argued that the recording of conversations did not fall under the definition of oral communications as defined by this section because deputies did not have an expectation of privacy, and they don't. But unfortunately, the state decides that, well, they want to let a jury hear it. The state filed a traverse and demurrer admitting that all times during the recording conversations, the deputies were acting in their official capacities and added that the deputies were using office phones and cell phones. However, the state argued that whether someone has a reasonable expectation of privacy is an issue of fact for the jury. That's not true. There's already established cases. Smith v. Cumming, McDonough versus Fernandez-Rundle, Department of Agriculture v. Edwards. So it was denied. They denied the motion to dismiss there, and now he's facing these 25 years in prison again. But if we dive a little bit deeper into the Florida wiretapping statute, and how it says it's unlawful for any person to intentionally incept or endeavor to incept any oral or electronic communication. That means you're guilty of it. But oral communication means any oral communication that is uttered by a person exhibiting an expectation that such communication is not subject to the interception under the circumstances justifying the expectation. So that means a non-public conversation, a private conversation. Anything you do with law enforcement, not private. And it even goes further. For an oral conversation to be protected, the speaker must have an actual subjective expectation of privacy along with a societal recognition that the expectation is reasonable. Reasonable, me and you talking in my home. That's our conversation. Not reasonable, me and you talking loudly and yelling with the windows open and people from on the sidewalk can hear it. Alternatively, leaning in at McDonald's in the corner of the room and talking something in your ear where you don't think anybody else could hear you. That could be subject to reasonable expectation. But if you're just sitting back talking normal where everybody can hear you, not a reasonable expectation of privacy. Additionally, it has been recognized that meetings taking place in an office context have a quasi-public nature. And that's a good friend of mine, McDonough versus Fernandez, Rundle. Dr. James Eric McDonough has established some case law in the 11th Circuit in 2017. He's got a few more we'll talk about in another time, but he's a very powerful man that goes and argues his own stuff, pro se. Very powerful statement. The Florida Constitution recognizes that a public office is a public trust, and the people shall have the right to secure and sustain that trust against abuse. Public trust in public office is when you are a deputy and you're in that position, you hold an office of public trust. Thus, the Florida Constitution contemplates that public business is to be conducted in the sunshine. It means open. I think there's something missing here, but that privacy does not extend to an office place or business, and that's Morningstar v. State in 1982. So when you call a Walmart or you call a business, technically that court case says that there's no expectation of privacy there as well. It goes further. Moreover, individuals conducting business over the phone do not enjoy a reasonable expectation of privacy on business phone calls where the other part of the conversation records said conversation, even when business is conducted from the person's cell phone at home. And that's a 2006 case, and that is RH v. State. So there's so many cases that say that just because you're on a phone call doesn't mean there's expectation of privacy. It has to go with who you call and the nature of the call and what's going on. So there's so many nuances in that law that I don't see how anybody can be found guilty of it, because technically, don't you have to have some type of intent to commit a crime? In addition to this, the state of mind of Waite, he immediately emailed this in to the very same police department that's going to charge him. So that goes to the state of mind of this person. He doesn't think that it's illegal to do this, and neither do I. So when he sends this in to the very same department that's going to ultimately charge him, facing him up to 5 felonies for 5 years each, his mindset was that he's just trying to report this misconduct. If he didn't have this recording, they likely would have said, well, we weren't there, we don't know. It's he said, she said, but the recording is an independent, unbiased witness. And when they have that, they should have done something. Instead, they charge him. So when we go over the conclusion, you're going to be pretty happy about this. Because the deputies did not have a reasonable expectation of privacy when they spoke with Waite over the phone in their official capacities as law enforcement officers regarding public business, the recordings did not fall within the definition of oral communication, such that the wiretapping statute in Section 1A applied. Accordingly, we reversed the denial of the Rule 3.190C4 motion to dismiss the wiretapping charges and remand further proceedings consistent with this opinion. In all other aspects, we affirm. And you can see it here. It was affirmed in parts and reversed in parts, remanded with instructions. But unfortunately, the last statement here that says this is not final until deposition of any timely and authorized motion means that the state can appeal this. So you got to wait, I think it's 90 days, and then they can appeal it or not. Well, let me know what you think in the comments. Is this overreach again? Is this overzealous officers charging people because you tried to file a complaint against them? Or do officers have an expectation of privacy? I guess we'll find out in that 90 days if they do decide to appeal this and try to get this reversed. I think it does need to go to the Supreme Court of Florida. but likely will not. This is a 5th District Court of Appeals of the state of Florida case. However, it is binding across the entire state of Florida because there is no other cases that are applicable like this. So I want to thank you guys for watching, like, and subscribing. We'll go over some more cases like this. Leave some notes down in the comments. Let me know what you think, and I'll see you again soon.